Hello, everyone. Welcome. We are glad to have you with us today for this final webinar in our Protect What You Build IP series with the USPTO. Today's topic is Patent Basics and Commercialization. I'm your moderator, Jenny Alton from the New York Small Business Development Center Central Office. The NYSBDC is a U.S. Small Business Administration resource partner with regional centers at higher education institutions and outreach offices at other locations across New York State. Our free advising, education, research, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. I am very pleased to introduce your presenters for today, Liz Jackson, who is the Acting Director of the USPTO Northeast Regional Outreach Office, and Christine Nelson, Acting Regional Outreach Officer and Patent Examiner with the Northeast Regional Outreach Office. All right, now we're going to do a little bit of housekeeping, and then I'll let the ladies take it away for their presentation. So you know, attendees are muted and will not be on camera today. If you have any questions during the presentation, please drop them in the chat, which is only viewable to me and our presenters, or we also have the Q&A box available, viewable to everyone. And put those in as they come up. We will address questions at some specific points during and after the presentation. And we really appreciate questions from our attendees and love to get those answered for you. I also want to mention that should you need closed captioning, that service is enabled today for this session. You can find all of these things in the Zoom bar at the bottom of your Zoom window. Okay, so I will now turn things over to Liz and Christine.
Thank you so much, Jenny. Give me 1 second to share my screen and share our slides. It is wonderful to be here again. I was here for IP Basics a couple weeks ago, and then Trademark Basics. And now, since I am a trademark attorney, I've brought my friend Christine to help me. She has been a patent examiner for many years, and she is an expert. So I'm very excited to have her with me today. And let me open our slides. So that is who we are. We are both from the Northeast Regional Outreach Office of the United States Patent and Trademark Office. And our goal is to teach as many people in the Northeast region about the value of intellectual property. That being said, we cannot provide legal advice, so this is just for educational and informational purposes, and it is cannot constitute legal advice for you. I apologize for that. Please consult with an attorney if you would like to. As we did with the IP Basics for our very first session, I just want to take it back to the very beginning and get a little bit nerdy for just a minute and take it to the Constitution. This is Article 1, Section 8, Clause 8, and this is where intellectual property started. The Founding Fathers wrote that Congress shall have the power, meaning Congress can pass a law, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. What all that means is that this is a government authorized monopoly, meaning that the government can give you a patent and only you can make your invention or offer it for sale or license it or do whatever you want with it because you can exclude others from doing it. It does not last forever, it says for limited times, and the goal of it is to promote the progress of science and useful arts, meaning that when you apply for this monopoly, this patent with our office, and we give you this monopoly, you have to make your invention public with the idea that the knowledge you've created, this new technology, your new invention, we want everyone to benefit from that new knowledge, get educated on it, and perhaps maybe create the next big invention. So that's why the government is in this game. We give you a monopoly for a limited time, and you hopefully move progress and innovation forward. So that was a little bit of history. Now let's get into the nuts and bolts of what intellectual property is. So you know what property is. personal property, things you can hold, like a mug or a purse or a pen, or if you're very strong, a car. There's also real property, like land and buildings, also known as real estate. But there's another type of property called intellectual property, and this is the property that comes from our brain. It's not tangible, you can't hold it, it's intangible, but it is no less valuable than any other property you know. You can own it, you can sell it, you can buy it, all of these things, it is valuable property. In fact, an executive of Coca-Cola was once asked what their most valuable asset was, and he said, without a doubt, our registered trademark, because we could lose all our other assets, everything we have, and still be able to completely rebuild if we had that trademark. So intellectual property can be your most valuable asset sometimes. So you're going to see this a lot. This is kind of the course of what we'll be talking about today with patents. So the very first step will always be determine the type of intellectual property that you need. And so the four, we've talked about it before, are patents, trademarks, copyrights, and trade secrets. Because again, intellectual property, I want you to think about it as tools in your toolkit. You don't need all of them, and you might need a few, and you might need some at different times. So I want you to be aware of all of them. And today, we're going to do a deep dive into patents, this for protection for new inventive ideas. Christine, are you ready to take it away?
I am. Yes, thanks so much, Liz. Okay, so talking about patent basics, we're just going to jump in on this specific bucket or tool in your toolkit. Next slide, please. Okay, so I'm so sorry, I skipped ahead. Let's go back one. Whoops. Okay, great. So, so Liz already talked about the types of IP, intellectual property that you might need. And so the second step is going to be to determine if your invention is patentable. In order to do that, super helpful to know what a patent is and what is patentable. So let's go with some definitions right off the top. Next slide, please. Okay, so what is a patent? Um, Interestingly, a patent is not the right to do something, it's actually the right to exclude others from doing something. So, your right is to exclude others from making, using, selling, offering for sale, or importing your claimed invention. You don't have to necessarily make your patent. In fact, one of our favorite little trivia pieces at the Patent and Trademark Office is what president is the only president to have a patent, a US patent? And it's Abraham Lincoln. And it was for this boat that kind of lifted up and could go over a shoal. And but it never went to market. It never became a tangible invention. It was an idea that he patented. So you don't have to make your thing, whatever your thing is. But with that patent, you'll have the right to exclude others from doing so. A patent is for a limited term. I think Liz mentioned that in the Constitution, that's how it's set out. We're going to give you this monopoly, but it's for a limited term. And different types of patents have different terms. We'll cover that. And also, patents are territorial. So there is no worldwide patent. We provide patents in the US. That's our job at the US Patent and Trademark Office. Next slide, please. So you're wondering, why do I want a patent? What is my benefit to this? And I'm going to give you a little example from real life. I'm big on examples, and this was my world this past weekend. So for the past, I don't know, 3 years, every anniversary, every birthday, every holiday, I have told my husband, "You're getting a new smoker," and he just wanted this smoker because he loves meat and he loves to smoke meat and grill and all that kind of stuff. Um, so he finally just got his new smoker and he's putting it together in the garage. And I went out to talk to him and I'm like, okay, so what makes this special? So his new smoker has some combination, and I'm going to get this all wrong. So if any of you out there know more about this, feel free to correct me. But also, I know I'm not an expert on smokers. But it has a doohickey that is new, that does something that the other smokers don't do. And we were talking about it, and I said, "Hey, I bet they have a patent on that new doohickey that does this fancy thing." because it was the only brand that he shopped for. It's the only one he was interested in because it's the only one that has this certain feature. So that is the value of a patent. It gives you that entry into a market that no one else has, and also the ability to exclude others from that market. So that specific smoker is the latest and greatest because it has this one thing, but no one else can make that until their patent times out. Another example, I'm just using things on my desk here, is Post-it notes. So I honestly don't know how I survived before these were invented, but I am old enough to remember life before Post-it notes. We call them all Post-it notes, and that's a whole trademark thing that we could get into, right, Liz? Um, but um, but when these first came onto the market, they were kind of expensive. Like I remember for the day thinking, "Wow, those are pricey. I'm going to be careful. I'm only going to use them when I absolutely have to." And after 20 years, when the patent had expired, then anybody can make a Post-it note. And these in front of me right now are made by Skillcraft. So not actually even Post-it brand anymore. However, Post-it, because they had a patent for the Post-it note, they had that exclusive right to the market for this product when it came out. Okay, so you can also use it as a marketing tool to promote it. So I'm sure you've seen patent pending. Patent pending means we don't have it yet, but we've applied for it, or patented. And just like Liz said, it's like property. You can sell it or license it. So what does that really mean? Here's a little example. Another little example from my desk. Here's a pen. So Christine Nilsson, developed the most amazing new type of ink. And I am so excited about my new ink. However, I am not in the pen game. I really, really have no interest in becoming a marketer of pens or a seller of pens or getting into the pen business. But I know that I have this valuable thing because I got a new ink. And I'm going to go to BIC or Skillcraft or Pentel or whoever and say, hey, if you guys want the exclusive right to this new special fancy kind of ink, you can buy it from me. And there I have value in it because I'm able to sell it. Okay, next slide. All right, so we've talked about what a patent is, and now we have to talk about if it's patentable. So what is eligible for patent protection? Next slide. All right, so the first four things you see in the what can be patented column, process, machine, article of manufacture, and composition of matter, are all called utility patents. So they are the most common. The majority of the patents that come into the Patent and Trademark Office are utility patents. I am a utility patent examiner. My background, I have a background in spinal anatomy and biomechanics, and so came into the patent office examining spinal implants. That evolved to orthopedic implants. I've also done some stents, so heart implants. I've done some corneal implants. And now I'm actually working in dental implants and dental technology. So those are utility, that's a utility field. I'm a utility examiner. But we've got these four types of utility patents. We've got process, machine, article of manufacture, and composition of matter. I'm going to, again, go with an example right here from my desk to help you understand what those four things are and how they're different. Okay, so I've got a stapler right here, handy dandy stapler. I actually did examine some surgical staplers in my time. So this right here has movable parts, right? I can make it go up and down, and it's got hinges, and it's got like a doohickey back here. Okay, so this is a machine. It's a machine because it has movable parts and pieces. There's many components to it. It's got the little place where you put the staples. Okay, so machine. A process would be, how do I use this? If I were to define the use of a stapler in maybe some very simple patent terms, it would be loading the device with staples, inserting some paper, and compressing the top to create a fixture between the paper and the staple. So those would be some process steps that I could describe. So it's how something's used or how something's done. In the surgical world, sometimes it would be a method of inserting a certain type of bone plate. So we're going to make an incision, and then we're going to drill here, and then we're going to put this together, and this is going to go in, and we're going to apply it this way. So very specific process steps. Okay, so process, machine. Article of manufacture is kind of, it's a little bit of a fine line with machine. So the article of manufacture in this would be like a staple. So it doesn't have movable pieces and parts, but it has something specific about it. It has a shape. Surgical staples could vary greatly because they could have maybe little barbs that help them stay in the bone better, or a certain shape to cross a joint. So that article of manufacture is going to be like it's something that can be used. It's utility, but it doesn't have those movable pieces and parts. But it can be described very finite in a finite matter. Okay, composition of matter, our fourth one. Little trickier. These are our chemical things. So if I were to take this staple and if I were to put a coating on it that maybe keeps it from rusting or somehow makes it more effective or hold better, that coating, that chemical process would be the composition of matter. Okay, so hopefully that was a lot of words. Hopefully that helped you understand the difference between these four types of utility patents and what they are. Okay, sorry, need a breath. So next we have an improvement of any of the above. So there are legal statutes for how we decide what can be patented. And they're 101, 102, 103, and they are legal statutes that we apply as examiners when we're evaluating something. And we need to decide if it's something that can be patented. We have to decide if it's new and useful. And then it also can be an improvement. And we have to decide if that's a logical improvement and if indeed it is an improvement. So an improvement of any of the above. An example of that would be, I used to use this when I would talk to kids, is the first toothbrush was actually made out of boar hair bristles in the 1800s, the first patented toothbrush. So that has improved since then. Improvements being maybe nylon bristles. And now we have improvements in toothbrushes to electric toothbrushes. So those are new, those are patentable because they are improvements on a previous device, patent, something that's come before. And that's how we move technology forward, is because we're disclosing what the original thing is so that it can be improved as well. Okay, so we have two more categories for patents. We have the utility patents, and then we also have design patents. And design patents are really directed to the look of something, so that ornamental design. And then we also have plant patents, and plant patents are asexually reproduced varieties that somebody has created that are new in the plant world. So we've talked about what can be patented, what cannot be patented. So laws of nature can't be patented. You can't patent gravity. You can't patent time, things that just occur naturally. You cannot patent physical phenomena. So you can't patent lightning. You can't patent rain. You can't patent waves. You can't patent abstract ideas. So something that is just in your head or that you can do in your head. So I can't patent 2 + 2 because I can do that in my head. Now you can, there are algorithms and it gets very complicated with math type things. But if it's a simple formula that I can actually do in my head, that cannot be patented. And you can't patent literary, dramatic, musical, or artistic works because those fall under the copyright protection. Next slide, please. All right. Whoops, sorry, I'm I'm a little behind here. Hold on. Okay, great. So we talked about that, those, we call them the bars to patentability. And when we say the bar, we mean it has to make it over that hump, over that bar. And so something has to be new, useful, non-obvious. And by non-obvious, we mean I can't just smush this thing with this thing like everybody has done for years. It has to be really, it has to take an inventive leap. And part of a patent is it has to be accompanied by a written description disclosing how to make and use the invention. So that written description is what the patent examiner sees. And we'll talk a little bit more about that coming up. Okay, so you think you have a patent, you have a really good idea, but you're just not sure if somebody else has done this already. Next slide, please. So what are we going to do to find out if somebody else has done this before? How do I know if it's new and non-obvious? You're going to search. You're going to do your research. And where are you going to look to see if this is out there? You can look at US patents, foreign patents, printed publications. So anything that has been presented at a conference or perhaps in a technical journal or is distributed to the public. That's a printed publication, and also on the internet. So that's a game changer, because if you disclose something on the internet, then there it is. It's out there for the world to see, and you definitely want to think about that in your strategy for getting a patent. So the first thing you want to do is search. And we will talk a little bit more at the end about our resources at the Patent and Trademark Office for searching. We do have a search tool, a public search tool. It's accessible on our website, which is uspto.gov. And we'll talk more about that later. And then another one that's just really, really right there, super basic, but people don't realize, is that Google has a search database for patents, and it's just Google Patents. So good place to start, just to see if what you think you've created already exists somewhere. All right, next slide. Okay, so we have determined that we need a patent. And now we know that it's patentable, because I've been through the what is patentable thought process. So what kind of patent do you need? Next slide, please, Liz. And we talked some about this. The three types of patents: the utility patent, the design patent, and the plant patent. That's really, it's got to fall into one of those three if you are looking to patent it. Okay, next slide, please. So now we're ready to apply. And what do I do? How do I get through this process? Again, I'm going to direct you to uspto.gov, because we have fabulous resources for first-time applicants that step you through the process and can help you with that. We also have a series going on right now. I think it's actually part 2 is today, a little bit later today. So if you go to our website, you'll see it's called Path to a Patent. And it does step you through in a little more detail than I'm going to do right now, the process for applying for a patent and for searching and things like that. So great resource that we have for you. Hey, and I just did a plug for that program that's later today too. So if you want to spend your whole afternoon learning patents, you can do it. Okay, so you're ready to apply. And you hear these words: provisional application, non-provisional application. What's the difference? And so let's break that down for you. So 2 types of patent applications. A provisional application is inexpensive. It's not the one that gets examined. It's kind of the first step application. It's not mandatory. You do not have to do a provisional application. It's just optional. If you want to file a provisional application, you do not have to file claims. And we'll talk about what claims are in a little bit. And that provisional application buys you a year to pursue your invention as a non-provisional application. So what does a provisional application do? It establishes a filing date, and that is critical. Timing is everything when it comes to patents, because once you have established that filing date, that is the date that your examiner is going to use to say, this was yours on that date. If I find something, if somebody has done something before that date, then it's probably not yours. It's not new. Somebody else did it. If somebody else has done the same thing after, it's not theirs because you did it first. So that filing date is really, really critical. You can establish a filing date with that provisional application, or if you choose not to do a provisional and just go straight to a non-provisional, the non-provisional will establish that filing date for you. The non-provisional application is a little trickier. It's more expensive. um, it has more requirements for what needs to be included in that non-provisional application, more pieces and parts. And so it's going to take you a little more time. Uh, it's also more expensive to file because it becomes published and it becomes examined. So that's where the expense goes. It's expensive to have someone take the time to do the job that I do in order to determine that patentability. So it is more expensive if it's going to be examined than just to hold that filing date for a year. Okay, next slide, Liz. So these are some of the fees that are associated with filing a patent. And there are more fees. There's an in-depth fee structure at uspto.gov fees. And just a little disclaimer, I did not check today to see if these are the current fees. They probably are, but it's possible they do change them without necessarily telling us the day that they change them. And so I'm hopeful that these are up to date, but if they're off by a little bit, please don't hold us to that. But you can see that there are different categories. There's the regular fee, which is that first column up and down, the regular fees. There are also discounted fees for being a small entity and a micro entity. And you can see it's a steep discount. It's much, much less expensive to file as a small entity or a micro entity. So let's define those. Liz, could you go to the next slide, please? Okay, so your entity status discounts. To be a small entity, you get a 60% discount. What you have to be to get small entity status is an individual or a small business or a nonprofit. Okay, that's it. That's all you have to establish. To be a micro entity, that one has a little bit more to it to establish and get that 80% discount. You have to be a small entity, but you also have to have filed no more than 4 applications previously. And you have to have an income that's not greater than 3 times the median income, which is that's a formulation, and I'm not exactly sure what it is right now, but that's a number that you can find. And then also, your to be a micro entity, you can't assign your patent to any other entity. Now, what does assigned mean? Assigned means there's the person who files a patent, the inventor, but that inventor could work for someone else. So my brother-in-law worked for a telecom company for many years and was influential in the beginning of cell towers. And so he developed that technology, but he was working for a telecom company. So he actually doesn't own those patents. The telecom company that he worked for does, because his invention was assigned to that company. So in order to qualify as a micro entity, you cannot have your patent assigned to anyone other than you. And if you are working for someone, and say you are working for a company, but you are going to file it as a micro entity, you're not filing it on behalf of the company, then any inventions that the company has aren't counted against your 4. Okay, next slide. All right, so we've started the process, we're ready to apply, and we're going to submit that initial application. So we need to talk about some of the parts of that application. So an application has to have an abstract. An abstract is like a summary. It's just a short summary. It has to be between 50 and 150 words. You will be notified by your examiner if it's too short or too long. And that abstract is just at a glance. What is this thing? Then there's a written description, and that written description is very in-depth. We call that the specification, and the spec is long. I've seen specs, actually, they're not all long. I've seen some specs that are 5 to 10 pages, and I've seen some specs that are 200 pages. And it depends on how in-depth or complicated the technology happens to be. That spec is going to give us some background. It's going to give us a summary of the invention. It's going to talk about how it works, how it's made or used. And then it's also going to describe drawings that accompany the patent application. So drawings, we also call them figures, are what is this thing? What does it look like? Now, you're thinking, I know you are, because y'all are smart out there. You're thinking, how am I going to have a drawing if it's a method? And that's a really good question. And so method claims oftentimes have figures that look more like a flow chart. So they'll have a box with text with an arrow to the next box with text to an arrow with the next box with text, which are the showing the steps of how that method proceeds. So some figures, if it's a method application, are going to look like that, and some figures are going to really just represent in 2 dimensions what that invention is. So if I get, let me think, what was I looking at yesterday? I was looking at some new um, dental pieces, like brackets and braces and things like that. And they're going to actually have pictures of and drawings of what those look like for me to analyze in depth with the specification. The specification is going to say, it's going to point to different things, and it's going to say this does this and this does that. And then I'm going to be looking at the drawings at the same time so that I can understand what the invention is. Okay, and then the final part are the claims. And as we mentioned, in a provisional application, claims are not required. In a non-provisional application, the one that gets examined, claims are required. And claims are really the fence of your property. So we call it the meets and bounds. The claims put that fence around exactly what you are claiming as your invention. That's why they're called claims. So you're saying, this is mine, it looks exactly like this, and this is what it does. And the claims are what are critical to the examination process. Okay. Wow, that was a lot. Next slide. Hopefully, I'm not overwhelming you. Okay, so filing your application, this has gotten so much easier. We have something called Patent Center, and it's all online. So you're able to just upload all the necessary documents, pay your fees, do everything online, and then you get your application number and you establish that filing date, that very important filing date. So much better. They used to call it a race to the patent office whenever someone would have an invention, and had to mail it in, and which one's going to get there first to get that filing date. But now you just do it all online. Much simpler. Okay, next slide, please. So next, you're going to work with your examiner. And this slide is the next slide, please, Liz. This looks really complicated at first, and I'm actually going to take a breath and drink a sip of water before I launch into this. So everyone, take a stretch, take a moment. Okay, we ready? All right, let's go. So first, that application is filed by you, the inventor, or filed by a company on your behalf as the assignee. And that's that big red box to the left. The patent comes in to that patent application comes into the Patent and Trademark Office. It goes to pre-exam. What does pre-exam do? They check all the boxes and make sure the pieces and parts are there, and that all the fees are paid, and that everything is proper and ready to go before it gets forwarded to the examiner. So before it hits what's called my docket, which is kind of like my to-do list of applications that are going to require my review, it's going to have been vetted by pre-exam, which is great. So it should come to me in a completed form, ready to go. So comes your application goes to your examiner. What is your examiner going to do with it? So they're going to analyze that. They're going to get to know that specification and those figures and learn what exactly is this invention. And then they are going to do exactly what you did. They're going to search. We're going to look and see, has this been done before? Is it non-obvious? Is it something that is patentable? And we're going to make sure that it meets all of those legal qualifications. If we say, hey, look, this meets all of those legal qualifications and it's met that full definition, we can issue a notice of allowance at that point, and then the USPTO grants the patent. That doesn't always happen. And just so that you're very aware, it's much more common, at least in my technology, not every technology is a little different. It's much more common that there are nuances that we need to flush out by going back and forth with the applicant. So that's between the dark blue column and the column on the right where it says applicant an appeal and abandonment, that little circle in between is the back and forth the conversations that we're going to have. Now, a lot of times the applicant will have an attorney representing them, and that's who the examiner is going to communicate with. But sometimes we do not have that attorney representing the applicant, and we call those pro se applicants. So if you're going to do this all by yourself, and you can, then you would be a pro se applicant. And the examiner is going to create a full report for you of their first examination process, and they're going to send that to you, the applicant. And it might say, hey, this part's okay, this part isn't. It's going to be a back and forth. It's going to be a conversation where you then have a chance to argue or amend. So amend, change your claims a little bit, or argue that, hey, no, I don't agree with you, examiner. And then we just go back and forth. The outcomes, there are 3 outcomes that can happen with the patent examination process, and those are in green. So we already talked about the first one, is that the USPTO can grant that patent. The USPTO and the applicant can get to a point where we just decide that, nope, guess what? It's already out there. I'm so sorry, applicant. This isn't the news you wanted, but we can't grant you a patent application. And then it moves to abandonment, which means it's no longer, the application is no longer being pursued. And then the third thing that can happen is the examiner and the applicant can't agree. We just do not see eye to eye on how the law is applied versus how the applicants are interpreting that. And we go back and forth. And then it goes to someone else. It goes up in appeal. And then it is evaluated by the appeal board to bring in another perspective and another view. So that's the process. It takes time. And sometimes it's a little bit confusing, I'll admit, but it's also a great learning experience. And for the most part, examiners are really happy to have those conversations with applicants. We call them interviews, and to kind of flesh some of this out as we're figuring it out, because we really want to make sure that you are granted a patent application that is accurate for what you have as an invention, and that also is something that you can protect. Okay, so let's go to the next slide. All right, so we've been through that back and forth, and that really is the longest time period. It can take, gosh, I think anywhere from maybe 12 months to 18 months to 24 months. I'm not even sure right now. It's called pendency, and you can look up on our website what the patent pendency, the average pendency. Now, it's not going to be the same for every application based on how many back and forths or if it just goes straight through. So you receive your approval. This is the optimistic side is you've received your approval. What happens next? Next slide, please. You are issued a patent. And it looks like this. So on the left, you have the cover of a patent. And on the right, this is the cover page. This is the front page of the patent. And I'm just going to go through it just super quick. I know it's probably teeny on your screens, but you can see that it's a United States patent, and it's listed by inventor name. So it's going to have the inventor's name right under where it says United States patent. And then it's going to have a patent number assigned to it and the date of the patent. Now, that date of the patent is not the same as the date that it was filed. So you'll see that in little tiny writing, there's also a filing date further down. You can see the abstract gets published on the cover. So that's that 50 to 100 word summary. And then also, the most descriptive and accurate figure is also published on the cover of your patent. Okay, what next? So you've got a patent. Yay, you have succeeded in this process. And now, next slide, please. You need to maintain your patent. And in order to do that, there are different steps that you have to take. It is not our job. We are not an enforcement agency. So the Patent Office does not enforce that no one is infringing on your patent. That is up to you. So you have to monitor the marketplace for infringing products, and you also have to respond to that if you want to protect your patent and your intellectual property. If somebody starts to come over your fence, then it's up to you to say, "Hey, wait, no, 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 this is my fence, and this is why it's here." Um, okay, so what does the government have as enforcement resources? We have something called stopfakes.gov. I would encourage you to check that out. And that is managed by the International Trade Administration, ITA, which is also part of the Department of Commerce. We are Department of Commerce, and so is the ITA. And they help businesses to protect and enforce their intellectual property rights against counterfeits or pirated goods. They also provide information and guidance and trainings to businesses on how to do that. I'm not sure if they've spoken to you or not, but I do know that they do education as well. And here's an interesting little tidbit that I never knew before working at the Patent Office. Customs and Border Protection can seize and detain imported goods. So fakes that come in to the country, um, if you have intellectual property that has been granted by the U.S. government, then Customs and Border Patrol can enforce um, your intellectual property rights with that. If you don't have a patent and you don't have a trademark, you don't have a way to enforce it with CBP. Okay, whew. That's all the information that I have for you right now, but would love to take some questions. So if you have any, and if Liz wants to hop back on for, there are a lot of things that cross over patents and trademarks, and you've got us both here. So would love to entertain some questions.
Perfect. So one that we have right now is, can you tell us, is the Google Patent Database only for the US or is it international?
Oh, that's a really good question. I don't know the answer. I actually don't use Google Patents as an examiner, so I don't know. Um, Boy, that would be, yeah, I would do a simple search. I would type in just a few keywords and see if you pop up with some international patents as well. If they're international patents, sometimes they will start with WO and sometimes they'll start with other letters. US patents always start with US and then a number. The way to recognize if it's an international patent would be it'll either start with WO and then a number, which is the World Organization. There's a treaty between many countries that are covered by the WO patents, and then or it might have like DE, which I think is Germany, or anyway, it'll have different letters before the number if it's an international patent or a patent from another country.
That is very helpful. I just looked it up just on Google Patents, and it does say that it's patents from all around the world. So what Christine
Nice.
just said about being able to distinguish them is going to be very helpful when you're on Google Patents.
Thanks, Liz.
Absolutely. Thank you, Christine and Liz. We do have another question, but it's a little bit more involved, and I want to make
Mhm.
sure that we have time to get to Liz's materials. So I'm going to hold that one for now, and
Okay,
then let's go ahead and do Liz's section, and then we'll get this more involved question and any other questions that anyone has.
great. Thank you.
Sounds good. Yeah, we want the opportunity to talk about our resources. So first of all, we have so many free things on the USPTO.gov website. We are providing free trainings and free resources all the time, including the Path to a Patent, which I have signed up to take. I believe it is at 3 p.m. today, and it is how to write a provisional application. So incredibly, just a free 1 hour class about a very practical skill. But please check out uspto.gov/free services. Just pick the topic you want to learn about. Incredibly useful. So this is a new thing we have called the IP identifier, where you can essentially put in, here it says, where do I start? And you can select, yes, I know what type of IP I have, what type of intellectual property I have, or no, I do not. And if you say no, this system will help you identify it. So if you say a stapler, it might say it could be a utility patent. If you say a song, it might say a copyright. So it helps you identify. Very cool tool. Play around with it. And this is if you go to uspto.gov and click on patents, although Christine and I recently found out that we will be changing this interface, not quite yet, but coming up. And then you will just come to our website and there will basically be two big boxes, patents and trademarks, and you can click on the patents box and it will link to all these resources right here. But lots of patent basics where we explain this again. If you can't get enough of what Christine was talking about today, lots more education there. And then also how to apply, and then how to get assistance while you're applying, and then what you need to do to maintain that patent afterwards, and links to all kinds of helpful resources. That's uspto.gov/patent. All right, so I guess we're really selling this today, but it is a terrific program called Path to a Patent, which is essentially a free training service series that covers everything from the basics of the intellectual property. And there's a session on how to search and see if someone else has already invented this before, what you'll need when you draft your application, how to submit your application. And I believe it's a whole series, but you can choose to just take parts that are most relevant to you as well. Again, all free, online, terrific resource. Oh, and I should say we'll send these slides afterwards, so you don't have to worry about taking out your phone and scanning the QR code now if you're under the gun. So this is also the patent public search that Christine mentioned, and feel free to come back and talk about this if you want, Christine. But this is where you can go on our website and try and search yourself to see if somebody else has already invented what you invented. And you can do the basic search, which is a lot easier. You can type in the name of what you've invented or the owner name, or you can do an advanced search. So this is our USPTO Patent Pro Bono program. Again, we're pro bono, meaning that an attorney will provide legal services to you for free. And this, like our micro entity and small entity requirements, there are requirements to be a part of this patent pro bono program, and they include income, knowledge, and what your invention is. But please look into it. It's a great opportunity to have free patent legal help in preparing and filing your patent application. This is our Inventor's Assistance Center. So if you're starting to file, and all of a sudden you realize you have a question about this process, or all of a sudden you get stymied, please contact them. They are all former supervisory patent examiners or experienced former primary examiners, and they will explain what happens next in the process or explain the whole procedure to you. We also have, I don't think it came up at the beginning today, but we have the United States Patent and Trademark headquarters in Alexandria, Virginia. That's where Christine and I are both based out of. We have regional offices in Detroit, Dallas, and San Jose. We have community engagement offices in Bozeman, Montana, Salt Lake City, and up in New Hampshire at the University of New Hampshire. And then we also have patent and trademark resource centers all over the country, which are essentially in a public or state or academic library where there's going to be a librarian, usually a business librarian, who knows about patent and trademark, knows about our online system, can help answer any questions, how to apply. In fact, Christine and I will get to meet all of them next month. They come to campus and get refreshed on everything. So all these librarians will be coming to our campus to learn all the latest news about patents and trademarks. And then they go back to their libraries and they have that wealth of knowledge to share to you. So please look up, you can go to our website. It should be at the bottom, PTRC, and see which PTRCs are nearest to you in New York. We have several. Oh, this is my personal favorite, law school clinics. So we have more than 60 across the country. And essentially, these are clinics of law students that want to do patent and trademark or copyright law. They want to do intellectual property law, and they need to practice. So they represent clients for free. Don't worry, there is an attorney that is overseeing them. I was in an intellectual property law clinic myself at American University's law school in DC, and I got to represent people who applied for trademarks, and it was wonderful practice. So you get free legal services, and they get to practice being an attorney. It's a wonderful program. You can go to our website and find a law school clinic that is near you, that has been certified to work before the U.S. Patent and Trademark Office. Oh, yes, we're covering stop fakes again. I think Christine covered it, but it's an important resource that will make sure they'll assist you in making sure that other people are not infringing your rights. And they actually do this in regards to patents that you have and copyrights and trademarks. All rights you have, they will help make sure you can protect them. Oh, and follow us on our socials. Um, if you'd like to learn more, we're constantly posting fun, exciting things and also educational tools. So with that, shall we do questions again? Or is everybody ready for lunch?
Yes.
Yeah.
Yes to both. Ready for lunch.
Yeah.
And let's do some questions before that.
Sure.
All right. Thank you so much for sharing this, both of you. And I do want to mention, as we wrap up today, we're going to do Q&A, and then there will be a survey if you are able to give us some feedback on today's session and other things with which we here at the NYSBDC can assist you in education. Of course, we have our core services of our no-cost business advisement, but we also have free research services, and then what I'm involved in, education. And we do love to hear what else people would like to know about and get some information on. Okay, now for this a little bit more involved question, we have someone with us today who recently learned that there's another person who has created a website and Facebook page the same month that they created a Gmail account and a LinkedIn page with the same name. They are a well-connected business owner in this same small town, but this attendee doesn't think that they have registered the business name officially. Is there anything this attendee should know or consider before approaching this person and crossing their fingers? They've been networking with this name for well over a year, our attendee. So they are hesitant to change that name after that year of networking. All right, ladies, what suggestions or tips might you have?
So it sounds like this is a trademark issue, not a patent issue, because we're talking about the name of a company, which we are happy to ask questions about. So essentially, you both started using this name at the same time, which means you might have common law trademark rights in that name, but essentially, whoever files first with the United States Patent and Trademark Office has the presumption of ownership for for countrywide trademark protection. So something to think about filing for office. Usually we don't say that you have to register for a federal trademark, but one of the reasons why you might is if you're worried about somebody else using your trademark too. And it seems like you might. But again, not legal advice provided here, just something to consider to apply to our office for a federal trademark.
Fantastic. Thank you. Yes,
Oh,
Liz, go
and
ahead.
oh, Christine double checked me. The path to a patent program today is at 2 p.m. So you can get a snack, take a quick walk, and then learn more about patents.
Perfect. Um, so I do want to ask a question. And first of all, I want to invite everyone, if you have questions, please drop them in the Q&A or the chat so we can get those answered for you right now. And this is a question I always like to ask our presenters. So Christine,
Mhm.
where do you find small business owners running into trouble the most when they are trying to apply for a patent going through this whole process?
Okay, so that's a really interesting question. My first technology that I worked in, I actually didn't work with very many small business owners because I was working with surgical methods and surgical devices, and those are big companies typically. But now, actually, in dental, where I'm examining now in dental, I have more pro ses. I have more people who are filing for themselves, and I think that the biggest hurdle is education. So, doing your due diligence, doing your research, making sure you have all the parts of that patent application, making sure that you understand how those claims need to be phrased and the do's and don'ts of writing patent claims. And again, I believe that we have those resources on the website. The Path to a Patent series has, I think it has one section that talks about writing claims and writing your specification. So educating yourself, if you're going to do it yourself, um, from the advice of a patent examiner is just make sure that you've educated yourself so that the process goes smoothly. And then the other piece that I would say is don't hesitate to ask questions. That inventor assistance center that Liz mentioned, fantastic. It's staffed by former supervisory patent examiners and primary patent examiners. These people know their stuff. So if you get stuck, ask questions. Try to find the answer, but also, ask questions.
And you can also ask questions of the patent examiner or the trademark examining attorney who's reviewing your application. I think some people think this is an adversarial process, like we don't want to register or grant patents and you do want it, but it's actually not. The way our laws are written is the presumption is we want to grant a patent and we want to register a trademark. If we run into some reason why it's not registerable or not eligible, that's what we're dealing with. But we actually are on kind of the same side. We all want to register.
Absolutely. Kind of a follow-up to that question then. We serve small business owners here at the New York Small Business Development Center. And so we have a lot of people who DIY what they can just due to budget constraints and such. Are there certain points at which you might recommend, okay, if you're running into this type of situation, it's time to bring in some outside help, like a patent attorney or whatever. Are there any, specific situations or conditions where you see potentially small business owners needing some extra help?
So I'm going to say it's just like anything else. If you feel like you're underwater and you need the help of an expert, and then that might be the time to reach out. It's not rocket science, but it isn't easy either. Is really what I would say. It's a process, and I think that just really depends on the individual. At what point they feel like it's too much, or I might need some more advice or some more help. I will say, please, we're just drilling this in, but use the resources available. The PTRCs, they are trained and they are fantastic. They are search experts and they have been trained by the patent office in your region. So, I would first exhaust the resources that are available to you, but also some of those resources are legal resources, like the pro bono program, like the legal program that we have with the students. So some of those actually are legal programs that you can tap into as well.
Excellent. And just one last follow-up question then. Are there any specific industries where you see small business owners maybe be less successful in getting their patents
Mm. Oh,
that
I have
might
such a
indicate a need for some help?
yeah. No, I
Yeah.
just have such a narrow view because I only work in one technology. The patent office is divided into many, many, many. We call them technology centers, and we also call our specialties art, which is kind of a weird word to use for it. But we're in art units, so we're in very, very narrow, like narrow lanes for what we work in. We don't diversify. Trademarks is different. Trademarks, they see it all. Um, so I don't know, Liz, if you have an answer to that as from the trademark side.
Oh, I could. I did want to say the one, because I talk to small businesses a lot, and the one that sometimes causes issues is software. There are some
Mm,
requirements for eligibility for a patent for software. So
mm,
I'm not an expert on that. I just know there
mhm,
can be. That being said, you should definitely have a trademark for your software app. So
mhm, mhm.
Absolutely. All right. Well, we are at time here, so we will wrap up for today. Thank you so much. This was a fantastic end to this series, and just I appreciate you so much, Liz, who has been with us the whole time, and then Christine coming and adding your expertise today was so valuable. Thank you. And thank you to all of our attendees. Thank you for your questions. We appreciate you and your support of the NYSBDC and our educational programming. Okay, so that survey is going to show up. If you have a minute, we'd love to get your feedback. But with that, I will tell everyone, have a lovely rest of your day, and we hope to see you on another webinar soon. Bye-bye, all.